Welcome, everyone, to the Buzz with BCLB. I see that we have tons of people rolling in. For those of you who have already joined us, you already know this introduction, but anyone who's new to the call, my name is Anjali Patel. I'm the Executive Director of the Berkeley Center for Law and Business, and we gather these webinars to stay on top of and dig into some of the most happening issues at the intersection of law and business. Thank you so much for joining us today. Cannot wait to get started on our discussion about the Chevron doctrine. But before we get there, I wanted to just cover a couple of points. Logistics. So we will be dropping in the chat very shortly a link for a CLE sign up. We encourage you to sign up during the webinar before it ends so that we can qualify you for earning the credit. If for some reason you're not able to sign up or the link doesn't work or a number of issues can come up, please just email us at bclb@law.berkeley.edu. Also, we're very excited to announce that we have another webinar coming up in September on climate homicide, the corporate liability for climate-related death. And this is still impending as far as date and time. So we're also going to drop in the chat a link to our webinar so that you can stay updated about how to sign up when it does go live. So with that, it is my honor to pass it on to the UC Berkeley Professor of Law, as well as Faculty Director of the Berkeley Center for Law and Business, Stavros Gadinas.
Anjali, thank you very much, and thank you very much for taking the lead in organizing this series of webinars and bringing this excellent panel together. I've been a corporate law professor in Berkeley since 2010, and one of my lasting passions has been the intersection between the corporate world and the administrative world and regulation. And obviously, the SEC features very prominently in that intersection. Today, I'm really excited that we are talking about an issue that expressly deals with how changes in administrative law and regulation end up having a huge effect on business, and not just on business, but also on the world around us. I'm grateful to be joined by an excellent set of panelists. And I'd like to invite all of them to introduce themselves. And I'll start by the way they appear on my screen. Sheila, let me start with you and ask you to introduce yourself.
Thanks, Stavros. Happy to be with you all today. I'm Sheila Ennis. I am a managing director and the head of our investor relations practice here at H Advisors Abernathy. I've been based in the San Francisco Bay Area for decades and been looking at these types of issues from a bunch of different lenses. I was a sell-side analyst, then I was an investment banker, and now I work in the strategic communications advisory world, working with companies just at their best and worst moments. Challenges and changes are always afoot, and so we dig in and help folks get through to the other side and back to normal whenever possible. As a result of that, I spend a fair amount of my time focused on transactions, but increasingly also on activism.
Thank you very much, Sheila. We'll need all your expertise to get us through this topic today. Raquel, let me come to you.
Hello, thank you for inviting me. I'm very happy to be here along with these esteemed panelists. My name is Raquel Fox. I'm a partner at Skadden. I'm a co-head of our SEC reporting and compliance practice. I'm also the head of our US ESG practice. Only this year can I say this, that I have evenly split my time between private practice and also at the SEC. So I've been at both places for 10 years and hope to offer my perspective through both of those lenses. So thank you.
Thank you very much, Raquel. But what's happening to the SEC is going to be a huge part of our conversation. Danielle, can you please say a few words about yourself? Oh, I think you're still muted.
Yes. I'm happy to be here today. And as you say, really interesting times, and these are important issues. So it should be a great panel today, a great discussion. I'm Danielle Fougere, President and Chief Counsel of As You Sow. We are a shareholder representative, and we represent shareholders and engagements with companies on a range of environmental and social issues. In particular, we focus on areas that are novel or remain unaddressed by issuers. So trying to get ahead of issues, working with companies to address those, to reduce risk and to take advantage of opportunities. And we have been working in this capacity for 30 years. So we've seen a lot of changes occurring, and this is a particularly interesting time, as I said. Thank you.
Thank you, Danielle. So as you see, we have perspectives from business on the ground, perspectives from the legal world and agency, and perspectives from the investor side and shareholder activists in particular. So I can't wait to get into the conversation. But before we start, I wanted to start with talking a little bit about the doctrine. I'll try to do what I do best, to be a professor for a while. I wanted to touch upon the Chevron doctrine, and I'll call on Raquel as the legal expert in the team to help me through that. So, Raquel, so Chevron was a major case by the Supreme Court in the 80s. And the core of the case was that when there is an issue about the extent of the agency's mandate, of the agency's mission, that was not expressly covered in the statute. There was some ambiguity about, was it something that the agency could do? Or was it something that it's outside of what Congress wanted the agency to do? That was a question, that's a question for interpretation, essentially. So what Chevron said was that, well, if we hit upon a question of interpretation like that, then courts should defer to agencies, should listen to how the agency sees its mission and follow the agency's view as long as it is reasonable, right? So now, Lauper Bright takes that away and says, interpreting statutes is what courts do all the time. That's what they're supposed to do under the Constitution. So why not do it in this instance too? Which to me sounds like a completely, reasonable view of what the Constitution could be saying. And it does seem like to be the order of things, the way, we teach the Constitution at, in middle school. So why so much fuss about it? Why is everyone so upset about it? And in particular, why are the progressives so upset about it? Because it was mostly a progressive doctrine, but the criticism, it wasn't a progressive doctrine, but the criticism tends to originate from that end of the political spectrum.
That was a fantastic setup. So thank you for that. So I'm going to be speaking on my own behalf, not on behalf of the firm or any of my clients. And remember, I'm a securities practitioner, not a constitutional law expert. But I do want to thank my partners, Shai and Parker, who gave me lots of good insights on the Supreme Court as I was preparing for this panel. So Stavros, you're absolutely correct. So Chevron has been the bedrock. I said I've been practicing 20 years. Well, that's been in effect for 40 years. So all the time that I have been practicing, I have thought about Chevron deference. And I thought about it being from Texas as a Texas two-step. So it was kind of like, step one is Congress directly speaking on this matter, on this precise issue? And if not, did the agency offer a permissible interpretation? So was it reasonable? And then Lauper Bright came along, and they actually answered a narrow question of law on, fishery management law, kind of technical. But in that question was a much larger question. I like to say a much bigger fish that you described. Mm-hmm. So you're correct. So the majority opinion said, well, yeah, this is, as opposed to a Texas two-step, this is turned into a break dance that's like dizzy and confusing. It's unworkable, and courts do this all the time. We interpret. But the dissenting opinion came along, and I think this was really the question that you're getting at for me. They said, and I'm paraphrasing here a lot in support of Chevron, it was basically like, well, who do you trust more in making nuanced decisions? Nuanced policy decisions. Is it agencies or is it judges? And agencies is where you have these, subject matter experts, think scientists, economists, financial experts. So maybe those are the people that should be deciding those kind of technical questions, as they have in ambiguous times for the last 40 years. And then Justice Kagan gave this kind of interesting example about the Grand Canyon, Stavros, that you pointed out during our sessions. And she said, well, restoring the natural quiet in the Grand Canyon, if that's the purpose of the statute, well, who's going to decide that? Is it going to be a judge, or, like I said, these technical experts? But what I think is can be challenging is the line drawing between what is policy versus what is a legal interpretation. And I'll stop it there for now.
No. It's this idea of agency expertise. I think you're right. It's at the core of the decision, and it sounds. And if you think about it, then it makes you rethink this traditional, as I said, middle school view of what courts do and what agencies do again, because there is this need. If you think about it, most of the statutes, including the SEC's one that we're going to discuss in detail in a little bit, have been drafted many decades ago. No one in the 30s could have predicted, crypto or securitization or a lot of these things that we are dealing with today. So the need to reinterpret the agency's mandate comes up all the time.
All the time.
But then this question about agency expertise sounds something that seems well confined into the some room in Berkeley Law School where we talk about this, and it's very hard to connect kind of this to the outside world. So I was wondering if I could ask you to tell us a little more about what does this mean, this question about agency expertise, what does it mean for the administrative state more generally, and how does it reverberate to the outside world? And
and kind of like, what are the implications going to be?
What are the implications for the administrative state? Yes.
Yeah. So one kind of thing to remember is Loper Bright didn't say there's no delegation to agencies. It just says that if it's not clear, then the court can decide. But statutes in Congress can most certainly still delegate to agencies for their agency expertise in these areas. But like I said, I think that harder question is also just trying to decide, was it delegated or was it not? Because I don't think, and a lot of times in statutes, it's not clear, like, you SEC, you're supposed to figure out this nuanced part of section, whatever of the statute. It's usually not quite that crystal clear. But what I think this means is it has a significant impact on administrative law. I think we're going to see an increase in the number of challenges, as well as the likelihood of success of those challenges. And what does it mean for agencies? Like, I think about when I was back at the SEC trying to think about what the rules should be. Of course, we were always trying to do our best and, do that carefully. But it means that agencies are going to be under more scrutiny. They're going to be looked at more closely, particularly were they working within these bounds. And what it means is there's a careful rulemaking process and a big premium on the notice and comment process, which has always been important. But for the folks in the audience that are sending in comment letters, that continues to be very important. And I think it's just going to, there's like I said, a premium on that. In cases of a legal interpretation, when you're writing in your comment letters, try to provide the agencies what you think is your best articulation of the legal arguments to convince the agency that this is the right reading. But then on the flip side of that, if the agency does have discretion to interpret certain things, I think the commenters and companies and all interested parties should be trying to tell the agencies how they should use that discretion and really provide meaningful comments and support and data.
So that's fascinating, Raquel, and it allows me to also to connect the conversation that we've had with views from the other panelists, and I'd like to open it up to the other panelists, because essentially you're saying that this process, which we thought as internal to the agency, kind of this notice and comment process and letters and everything, which we thought was an attempt from the agency to understand more about the substance of the rule that it was considering. Now it has a second audience, and that's the court, that ultimately is going to decide. It's going to read all that. It's going to study all this case, and it's going to decide, has the agency kind of moved beyond its mandate or not. So so that's what I'd like to ask Sheila and Danielle. I was wondering if you can give us some sense about how do you think this fits with other recent Supreme Court cases and kind of the general climate for businesses in the Supreme Court.
I can jump in first. Just a couple of things to underscore is that this decision is remarkable, not just because it's overturned 40 years of steady precedent. It's been cited to over 14,000 times. So certainly in any of the, in the first 1,000 times, it could have been overruled if it was unreasonable. And also that it's the Chevron deference simply allowed agencies, it gave deference to reasonable rulings, which still left room for the court to say that was an unreasonable interpretation of the statute. So I think Chevron should be, in that context, it's an astounding ruling, and it does create, it is likely to create great uncertainty in many areas. There are thousands probably of agencies that there may be challenges. And I put this in the context of two other rulings that came down from the Supreme Court. One was corner post. So traditionally, if a statute did not have its own statute of limitations, there was a 6-year statute of limitations in effect. So after 6 years, a regulation would be settled law, and companies could go forward in reliance on that. The Supreme Court has found that there is no longer a 6-year statute of limitations. If a company didn't exist at the time that the statute, during that 6-year period, and it can claim harm from the regulation afterwards, it can now challenge those laws. So what we thought had been settled laws and regulations, and companies have relied on those regulations, suddenly they are put at risk. And companies who have invested, who have complied with the law, maybe put it at a disadvantage to other companies. So that again adds to uncertainty. And then there was a third decision, and this was an SEC decision that said if an agency, like in this case it was the SEC, went through an administrative tribunal, imposed a penalty, and the court took power into itself and said, no, if you want to impose a penalty, you need to go to the federal courts and have a jury trial, something that makes enforcement extremely costly and difficult and could extend over years, even for a single case. And so all of those three put together, I think, create great uncertainty for companies, for investors, and for the public who are protected by many of these laws. So,
thank you very much, Danielle. And Sheila, I'm sure companies are filled with uncertainty. Isn't that right?
That is absolutely true. I'm starting to think about this as uncertainty is really a feature, not a bug. And so we really need to prepare ourselves and have been in a very dynamic market certainly punctuated by the pandemic and sort of like, wow, what are we going to talk about now? We don't really have any idea what's going to happen to the company. And so how do we make disclosures of key metrics, and how do we decide what to provide guidance on in that kind of an unprecedented situation? And so I think actually what began at that time to really work well will continue to serve companies well as they go through these periods where they've put a bunch of time and energy into figuring out ways to comply with laws that they felt were coming down the pike and regulations that they felt were coming down the pike very quickly, and now maybe slowing down. They, I think, have in some cases recognized that the work is very onerous, but it is done. And so what we are hearing from our clients is frustration, certainly, about the changes, but also a little bit of a resignment to, okay, we've got a bunch of information here. It is material to our business and to valuing our business, and in many cases can be a positive. So it all is not lost.
Yes, I was about to say, let's put a name of the elephant in the room and talk about the climate disclosure rule, because once I saw Loper Bright, at least for me, that was the first thing that came to my mind, because it's been such I would say one of the marquee initiatives of the SEC in the last few years, certainly the one that has elicited the most public attention, the most extensive commentary. And this is not, this is a very prolific SEC, but this one was a very important one. And the question of the SEC's mandate to pass that rule has always been central in criticism against the rule. I would say Commissioner Pierce, a Republican appointee to the commission, had famously quipped that we are not the Securities and Environment Commission, underlining the importance of the extent of the agency's mandate as to passing these rules. So this, the SEC ended up passing a watered-down version of the climate disclosure rule, which is now stayed while courts are going through the appeal process, and everybody expects that it will go to the Supreme Court. So let's start with the easy question first: predictions. So after Loper Bright, Raquel, as a legal expert, what do you think? What are the chances of the rule surviving in the Supreme Court? Are they higher? Are they lower? What do you think this decision means for the climate disclosure rule?
So, being a lawyer, my risk tolerance is low on predictions. So, but I'll give you two predictions. So, one, I don't think that this case is going to be decided this year. It's at the Eighth Circuit now. And I would be surprised if it didn't go to the Supreme Court. And I think as practitioners, and what most of my clients are saying, they're like, well, what do we do now in this uncertainty? I think that that's really the challenging part, is companies trying to figure out, well, we don't want, maybe we can take our foot off the gas, but we can't put on the brakes. So what do we do in the interim? How many resources should we allocate to this, because we don't know what's going to happen, but we don't want to get flat-footed. So I think that's kind of the practical place where companies are, and trying to figure out what makes sense for them to do kind of as they wait. Thankfully, the SEC said that they were going to be clear and crisp, and they said, we'll give you new implementation deadlines after all of this litigation is settled. But like you said, even before Loper Bright, even just with the major questions doctrine and the West Virginia versus EPA case, I think that already kind of pinpointed some of the challenges that the SEC would have in the rulemaking. But I think Loper Bright just continues to underscore that, because it goes right at, does the SEC have authority under its mandate, which is something the court would decide. And then I also want to remind folks, like, in other instances, when the SEC has had what like Congress said were specialized rulemakings, like climate, I mean, not climate, but resource extraction and rules like that, those were done through actual congressional statutes that prescribe for the SEC to enact those specific rules. Whereas climate, it wasn't a specific rule, of course, that Congress put down to them.
Yes, the Dodd-Frank especially applies some of these.
Right.
The Dodd-Frank Act especially applies some of these acts, as you mentioned. So let me go back to Sheila and ask, now that we're talking specifically about the climate rule, you mentioned in your previous comment, Sheila, about kind of this, the conflict that's going on in business's mind about how do I handle this? How do I move with that? So I was wondering if you could tell us more specifically about the climate rule. How is this playing out in your practice and in your experience?
Yeah, I think our companies recognize that the compliance with the SEC is stakes to play, but it's not the only initiative that they have to be solid on. They have many other stakeholders to consider, and the sunk costs associated with doing the building out the ability to measure and disclose with regard to climate impact is well underway, and there's good information there. What we do with our companies is we try, it's not always easy, but we try to sit them down and have them recognize that these types of disclosures are actually a credibility building exercise. And so to the degree that they can, rather than just constantly resist them on their face, look at the ways that they can enhance their ability to not only compete, but to compete for talent, to compete for supply chain partners, and of all of the stakeholders that are relevant. These problems are not going away. They're not happening in a vacuum. It's not a yes or no question by any stretch of the imagination. And so the mindset needs to change, and it needs to be viewed as an opportunity. Then a company is in a position to start looking at a thoughtful balance between the right disclosures for adding value to the decision-making process about owning their stock. And we think that there are some basic steps that can be taken in order to do that. You can decide on what you will disclose. How you make the decisions on which metrics to disclose is your own decision as a company. There are certain bars that you do need to meet, but by and large, you can have a policy that you of your own to sign. I think it's absolutely critical, however, that you then also articulate the rationale for the metrics that you've chosen and why they're relevant to your business and how they work internally in running your own business and making decisions about your own business. And then the last sort of big picture rule is to pick areas where you can be consistent. Don't cherry pick data. Don't talk about this one, that quarter, and this one, that quarter. People do need to see progress, and they do need to see that they're getting visibility to an issue that actually matters, not necessarily only to the environmental issue that it maybe addresses, but to how it works within the company. Are we getting the right people to manage this kind of stuff? How expensive are they? Is it changing our business model in the way that we need to move forward? And providing visibility and rationale to those thoughtful, balanced metrics is really the life raft in this crazy, sometimes seeming very rapidly changing environment. And quite honestly, the advice there is not so different from day one pandemic. Do we have to report? We don't even know. We don't even know where half our inventory is on this earth. And so it's very similar. Decide what you can know, decide what's relevant to your business, articulate the rationale for all of that upfront. Don't keep that under under your wing, and then find ways to be consistent?
Yes, it is. I have to say, I can't constrain myself by saying that I'm really interested in company efforts to self-regulate their conduct in this way, and I think this is gaining ground in part because of what you suggested, Sheila, that there are a lot of stakeholders who have these questions. So let me get to Danielle, who is one of those stakeholders and a very vocal one at that. And Danielle, I wanted to ask you, how does the Lober Bright and the scenario where the ESG climate rule doesn't get struck down, how does that look from your perspective, and how do you think this is going to affect your efforts to push companies to take more action for disclosure and for reversing climate change more generally?
Sure. At first, I will make maybe not a prediction, but I do want to underscore that the climate disclosure rule is just that. It is a disclosure rule. So it's requiring companies to disclose material information, and materiality is what's important to investors. What do they need to assess risk and value? And how do they make decisions amongst competing companies and where to invest their money? So this isn't a climate rule. This is a disclosure rule to give investors the information. And so that's the first point. And I would go back to, in a normal world that was following precedent and statutory design, what the SEC rule says is that they have authority to make such rules and regulations as the commission may prescribe as necessary or appropriate in the public interest for protection of investors. And so this rule didn't come out of the void. This rule came out because investors had for 10 years been working with companies to obtain disclosures about what companies were doing with regard to climate. So what were they measuring their emissions? If so, what were those emissions? Do they understand where the risks lie across their supply chain? Have they addressed physical risk? Are they innovating? Are they increasing their efficiencies to reduce their emissions? Are they prepared for upcoming climate regulations? All of these things are important to investor decision making. And so investors were asking for this information. So in essence, what so often happens is regulatory authorities follow where the market is going. And the market said, we need this information. Climate risk is real. Climate opportunities are real. Are our companies addressing the risks, and are they going to be innovating and competitive with international companies based in Europe that have much stronger climate regulations? So there are a lot of reasons why investors, for just reasons of where do we put our money, where is it appropriate, where does the risk lie, that's why they need that information. So from that perspective, what the climate disclosure rule did was simply follow where investors already were. So what happens next? If, in fact, the climate disclosure rule is found to be invalid, and shareholders will continue doing what they were doing before, which is working with companies individually. That's not particularly useful or beneficial. If we can have all of the companies operating off of a single disclosure standard, that's helpful to investors. It's helpful to companies. And so that is important. And also consistency and comparability. So we can work with companies, and we have, disclosures have improved significantly, but the companies aren't always reporting in the same way and on the same issues. So then from an investor standpoint, looking is apples and oranges. So having a rule that helps create that comparability and consistency is useful to investors. So, we are hopeful that it will remain intact. Certainly, we're disappointed in Scope 3 because we think Scope 3 is incredibly important to companies. They need to look down their supply chain. They need to know that their suppliers are addressing climate change and climate risk. So I think there is still work to be done. And I'll just say finally that shareholders will continue to work with companies on disclosures. And as Sheila said, there are reasons why companies investors are a significant reason why they will continue to disclose, we think. But also, I just lost my train of thought, but it's important. Oh, I was going to say, this is a world that has tremendous amount of information out there. And as Sheila was describing, it is beneficial to companies to get out in front of disclosures because everybody is measuring. People are putting out reports, they're scoring companies. And if companies aren't providing information that oftentimes we will look at a report and go to a company and say, we're concerned about this. And they say, well, that's wrong. And our response is, well, you're not providing information. So
exactly. So if I can, So if I can kind of use that remark to deliver on my initial promise for predictions, what we're all saying is that this kind of back and forth between the investor community and companies that we've seen play out in preparation of the disclosure rule is probably going to continue, even if the disclosure rule remains or not, because even if it remains, it's a limited disclosure mandate, but there are a lot of other things that investors are demanding companies to disclose as well. And what essentially we're going to like is this push for standardization and push for compliance overall, but this is going to be an ongoing conversation. So I was hoping that, so let me go back to the SEC for a moment. The climate disclosure rule is one of the most important initiatives of the Gensler SEC, but it has also been a very prolific agency during that time. It has passed a lot of new rules. And I was wondering if there are any other areas of SEC rulemaking that you think might be affected by Loper Bright. So during our call, there were conversations about cybersecurity, about AI and crypto, and diversity and human management rules. So I was hoping I could get your input about these topics. Raquel, would you like to get us started?
Sure, happy to. Those were all great topics, and you're correct that there is a lot on the SEC's agenda, even under the Gensler administration, and things that are still left that they are, I think, hoping to get done, including board diversity and human capital management. So of course, no crystal ball here, and like I said before, I think a agency action will be under scrutiny. And if these matters go to court, I think judges could, of course, interpret these things quite differently. Different courts and different judges may have different views. But I think even beyond Loper Bright, I think some of these issues topics you touched upon that are really out in the public domain, like cyber and not cyber, I don't think that's actually a good one, and I'll say why, but like crypto, they're really things that a lot of people are interested in. And I think it's going to come maybe more back to the major questions doctrine as to, is this an area where an agency should act kind of on its own? Or is this an area where Congress should act and provide some guidance as to what it thinks agencies should be doing in these areas? And crypto is kind of a good example because you see the SEC on the one hand feels like it has jurisdiction over parts of crypto. The CFTC feels like it has jurisdiction too. And then you see draft bills in Congress where people are offering bills on crypto as well. I think the question with all of these different things, not just crypto, is whether there can be some agreement in Congress as to what they think the policy should be for the agencies to try to implement.
Great. Danielle, would you like to go next?
Well, and that's an important issue because so many of these questions with this Supreme Court go back to what does what does Congress say? What does the statute say? Statutes were, as we know, put in place in many of these things decades ago. So they have to be able to live and change with the technology. We're a technologically based society. So it's incredibly important that agencies have the ability to respond. And we've seen that Congress currently can't make any laws. It's very difficult to get any laws, and unfortunately difficult because, as Raquel says, I mean, we really need guidance and Congress dealing with it and deciding who will be the authority and what do we need to address is important. But realistically, that world doesn't exist currently. And so that underscores the importance of agencies acting and getting, I mean, even now regulations are not getting in front of these issues. These issues have been out there for quite some time. So I don't know where that point goes, but it's a concern. And
well, and I would just
it goes to Sheila.
Well, I was just going to add that look, corporates are not anti-regulation. They want to understand what the rules of the game are, and they'll work with what they've got. The problem is when it's a moving target, and it's very costly in terms of resources, financial resources, but also attention. And really can be a challenge. And so corporations want certainty. Everyone wants certainty, but that ship has sailed. But they definitely do see regulation as generally a positive in order to level the playing field and understand what they're up against. And I think the good news is that there's a lot of well-established precedent in law and habit, if you will, and that underlies the relationship between investors and companies that is working and is it's going to be very tough to get the genie back in the bottle. I don't think you're going to see a lot of companies who want to have investors simply say, okay, we're going to pack up our bags and go back home and not report on these things. If you want to be a publicly traded company, that's stakes to play, right? If you don't want to be a publicly traded company, fine. Go find your money elsewhere or use your own, and you can self-regulate with your own self-regulated money. But that's not going to be for the majority, obviously, of the market.
And there's also this argument out there that people are making that Loper Bright in the long run, and I would say in the long run, may actually provide more stability in administrative law and for companies because things would be less likely to change over time or from administration to administration. So yes. There is that strain as well that you're hearing people say that's a potential outcome.
Yeah, this back and forth is untenable.
Yeah, so the idea is that we'll be constrained by kind of the explicit wording of the statute, whatever constraints that may impose, but that those would be, it would be harder to override those constraints for political motivations. And so the same, to translate it, if I may, a little freely, and maybe in language that practitioners can't use, but professors have tenure, so we hear now progressives complaining about the repeal of Chevron, but in a potential conservative administration or a Trump White House after November, we maybe the progressives would be grateful for something like that because it would be harder to interpret agency mandates in ways that are kind of broader. So that is the point, and that is an important counterpoint that we need to underline because it's very commonly discussed in the legal world.
Maybe I could just answer that quickly because I don't know that is a given. What Loper Bright does is simply hand the issue to the judges, and we have seen really. Especially in Texas, some of the decisions there's forum shopping. We're seeing very different decisions out of different judges. And so I don't really think that this will create certainty in any way until we get back to a system that is is really better ruled by precedent. I think we've gotten away from precedent, and there's less certainty. It's just, I have found as a practitioner, it sort of now depends on what judge you draw as to what the outcome is. It doesn't matter how well you follow precedent or take cases. It does, we're unfortunately in that reality where the judge matters, and there's too much personality in the decision making. So I don't know about that we'll get stability out of this decision.
Mm-hmm.
So, Stavros, can we actually hit on, like, we've talked a lot about like the SEC and ESG in the US. Can we talk about, well, maybe there's uncertainty here with the climate change rule, but is that all there is, and all that companies are thinking about? And there's been a dramatic shift, at least from what I'm seeing in my practice. So the SEC rules are on hold, but now people are really focusing on, especially multinationals, well, what do I have to do to comply with European rules? Because guess what? Those aren't being challenged. Mm-hmm. Those are locked and loaded, and the deadlines are coming fast and furious. And it's not just materiality like we think about in the US, it's double materiality. So there's a lot of work to be done there. And I think now multinationals are really starting to hone in on, well, these deadlines are about to come fast soon. And that's where a lot of the focus has been.
That's great. And I wanted to ask both you, Raquel, and Sheila about that, which is first off, give us a sense of the magnitude of the problem. Like, what percentage of your clients and your companies are affected by these rules? And how important these are, and how often do they bring these rules up in conversations with you? Absent the SEC, even if the SEC climate disclosure rule is repealed, there is the EU climate disclosure rule, there's the California rules that are coming into force. So it's not that we're going to be left in a completely unregulated world. It's just that it won't be the SEC that is creating those rules. So how extensive is this conversation, and how do you think, do you see your clients actively making efforts to comply with these other regulatory regimes?
Well, it could be because I'm based here in the Silicon Valley. It is often a conversation about attracting talent. And the branding and the mindset and the goals and mission of a company are very, very important to the young people who are coming up into the world and taking jobs and taking on the problems we've left them. Let's just call it what they call it all day, right? So it is top of mind. The question is, there was a period of time where many companies were leading with this in their quarterly calls and saying, we're very serious about it. We put the people in place. We've put the protocols in place to get measurement. And then there was a fairly long period of, we're on it and we're making progress and we're making progress. And then it started to have a deadline, right? That you were going to have to really disclose this stuff. And so it got more and more serious, and the mechanisms for doing so got more usable, et cetera. So there was maturity and progress toward getting there. With this, what can be characterized as a step backwards, it's a false step backwards, because you've got California and you've got the EU. So as I said before, it's hard to get that genie back in the bottle, regardless of whether or not this, noise in the market of woke versus anti-woke, it's going to be real hard to get that genie back in the bottle. It has changed how people talk about their initiatives. However, I will say that is a very tangible change. The work remains. The chatter about it is perhaps at a lower volume.
So I have. Let me also invite everyone to everyone among our listeners to submit questions to us through the chat. We have about 10 minutes left, but we already have a very good roster of questions that's been filtering in. And I wanted to touch upon some of those questions from the audience. So one, and I'll try to combine them, a couple of them in one. So audience members, please bear with my ability to synthesize. It's the opposite of what professors do, that we're good at analyzing. So so one of the questions, or a set of questions, has to do with what alternatives the SEC has. So there's, now that rulemaking is not available, can they regulate through enforcement? Can they regulate through pressure? Can they use other aspects of financial disclosure to push for more kind of for a more intense for more information about climate? So in other ways, can you think of ways to get around these problems, or are people concerned about ways to get around these problems? Any thoughts, Raquel? I'm looking to you as the lawyer in the group.
You're looking at me as a former SEC person
And a
as well.
former, exactly.
So that's interesting. So I don't think rulemaking is dead. I think it's just reasoned rulemaking, which I think most agencies are always trying to do reasoned rulemaking. But the SEC is special in that it has a comment process where they're always looking at companies' disclosures, and they're bound and they're required to do that by Congress. Either if you're a large company, once every year, and if you're smaller, every 3 years. But remember, the SEC said in 2010 that their rules already encompassed climate disclosure, and if climate was material, you needed to be disclosing it. So I think that through the SEC comment process, they'll be looking at this. They've already asked companies about their climate disclosure through comment letters. The SEC has an ESG task force in the enforcement division where they've been bringing some cases in this area. So it's not like if the climate rules off the table, that the SEC isn't going to be looking at ESG related issues. But regulating by enforcement, I don't think that that's something that they can do. If the rule isn't there, they can't just or they usually wouldn't go out and say, we're going to make the rule by enforcement action. I don't think that wouldn't be proper.
And I do think we've seen that there may, the cutting back on an ability to enforce regulations may weaken the agencies substantially. So we'll see what happens there. I think another avenue is guidance documents. So the SEC does put out guidance documents, and that's useful when they don't want to go to notice and comment rulemaking. I think there's, we don't want them to rely on bringing new guidance is really to interpret existing regulations. So it doesn't serve fully for new issues, but I anticipate that's at least one way to help companies and understand, where the agency thinks they should be going, especially around new or where they have some regulatory authority that can expand a bit to address some things. But I think in the end, we want notice and comment. That's the importance of regulatory agencies, is that they do take comments from companies, from the public. That's an important curb on agencies.
Yeah, so we actually do encourage our companies to be engaged and to make sure that they are helping to articulate why this approach is fair, it matters, it's useful, it's instructive, it's how we run our business, for instance. All of those rational approaches can help get to a rule and a framework faster. If everybody's just trying to be unreasonable and have absolutely nothing regulated, it's just nobody wants to work within that framework. It's not useful.
So I have some other questions that are really fascinating and make me believe in the wisdom of the crowds even more. So one of them is, I think it's mostly directed to Sheila, but I would love to hear your perspective as well, Raquel and Danielle, because it's very nicely and poignantly asks and says, what are common mistakes that you predict companies will make as a result of this uncertainty? And I find this a very exciting proposition. So Sheila, am I right in thinking that I should start with you?
Sure. It's hard to keep emotion and politics and all of those things out of company communications with their investors and other stakeholders. And so the mistakes that we see are moving too quickly to try to get a stake in the ground and not really having thought through what the ramifications for your own organization or at how you will compare. Investing is a relative business, right? And so you have to be comparable to other organizations in your world. And when you take a different tack and not particularly thoughtful way, you don't do yourself any favors. I think the other thing that people fail to recognize, companies fail to recognize, is that everyone has a megaphone, and the slightest, opinion, leader in quotes, can get traction and create reputational issues for you. And so the more you are prepared in what we consider to be peacetime with your well thought out rationale for the way that you run your firm, the way that you've decided voting rights will work or climate disclosures will work, the more that can be well thought out so that when somebody does knock on the door and say, we don't think you're doing that right, we have a pretty robust response to why we actually think we are doing that right. As opposed to, nuh-uh.
Great. Raquel, Danielle, any mistakes that you want your clients to avoid? And I have, we only have 3 minutes, so let me give you another option and you can answer whatever question you prefer. So the other question is, do we think that the repeal of Chevron, the fact that the Supreme Court goes and tells Congress, you have to act, is this going to change the way Congress thinks about its powers and its statutes? And is it going to change the kind of relationship between agencies and Congress? Will they demand more congressional intervention? Will it kind of jolt Congress out of its idleness, to say, or divisiveness, or and hopefully get them to be more guidance? So these are the two questions on the table. You have about a minute each for closing remarks, Raquel and Danielle.
So trick or treat. Oh, go ahead, Danielle.
I was just going to say, I would echo Sheila's concerns from an investor standpoint. If companies feel that we're heading in a deregulatory direction, therefore they can become lax either in disclosures or the way that they are complying with regulations, or just how they treat stakeholders. All of these things, I think, will not only create concern to shareholders, especially long-term shareholders, but as Sheila said, to employees who care about where they work, and may create much more focus, and more megaphones may be directed at them. So I think we're hopeful that companies will kind of keep a steady state, continue to be responsible in their actions and consider stakeholders. And then I just think it's Congress. I don't know that Congress it's going to take a while before that becomes a functional institution, I think, unfortunately.
Thank you, Danielle. Raquel?
We're running out of time, so I'll say it quick. I think companies should know kind of their ESG story, and they at heart are a business, so it has to work for their business. And then shareholder engagement, it's a year-round sport. And so I think that they should always keep that in mind. So thank you.
Absolutely.
Well, thank you everyone for joining us. Thank you, Stavros, Danielle, Raquel, Sheila. What a fascinating conversation. And I know very, very timely considering all the questions and practical advice that folks need in this time. We will be ending right on time. Do check out our chat just to grab yourself the CLE link as well as any other information about upcoming webinars. If you have any questions, we are at bclb@law.berkeley.edu. And with that, thank you all so very much. Thank you to our wonderful panelists. A silent round of applause for you all, and we'll see you next time. Bye, everyone.
Thank
Thank
you.
you.